Good morning, everybody. It is time to visit with our good friend Kim Baer from the Baer Law Office and talk about some things that honestly are, in some cases, are very uncomfortable when it comes to families.
Putting them off.
Exactly, and this is the time of year, obviously, when families get together, the holiday season, but this could be an ideal time.
Yes.
There
Yes.
to get together and sit down and say, no, something, this is unpleasant, but we need to take care of this.
Right.
Okay?
So I thought we'd talk about really kind of what's going to happen when something happens to you.
Because you have to think about it.
You do. I mean, it's inevitable.
Right.
You know, we don't like to think like that. But, you know, and the same thing with if you have elderly parents or you've got, maybe you have children and you're divorced. I mean, there's all sorts of things that kind of come up that people don't kind of think through because, number one, they think they'll be here forever. And then number two, they don't kind of think through what would happen if X, Y, and Z happened. You know, so I thought first we'd talk about a living will. And what a living will is that's the document that you fill out that tells your relatives what you want for life-sustaining procedures. In other words, if you are in a coma, when do you want to be, you know, basically unplugged? If you have a brain injury, when do you want to be, you know, when do you want everyone to stop keeping you alive?
Because that's the protocol.
That is the protocol.
If you don't have this, the idea is to keep you alive as long as possible.
Absolutely, absolutely. So, and it really, and so if you don't have a living will in place, and what happens is they go to your next of kin, and your next of kin has to make these decisions. And so I'll just share a personal example. You know, my brother-in-law earlier this year had a stroke. It was completely unforeseen. I mean, he was in his early 60s and was, you know, pretty healthy otherwise. And it unfortunately led to then a situation where he was put into hospice. And his next of kin was his 26-year-old son. And so his 26-year-old son was put in the position of having to make all sorts of decisions. And he did a great job, but you know, we all were worried about the fact that that was a lot to put on his shoulders. I mean, he's already dealing with the fact that he's losing his father, let alone making those decisions. And some of us, I mean, I have lots of girlfriends who say, hey, I love my husband to death, but that's not the person I want making the decisions. You know, I want my sister.
and that's a very valid point.
Right. Or, you know, and I don't mean to pick on men. I also have, you know, some male clients who have said, you know, I want my son to make my decisions, or I don't want my daughter to make my decisions. You know, so we all have different family dynamics that maybe you want to address. So that's just something. It's an easy document to fill out, and
it's pretty straightforward too, isn't it? It's
very straightforward. It has it gives all different kinds of scenarios, and you check the box, you know. And if you're not sure, you can always say I don't know, you know, and just leave it open, and then once you fill out the living will, have a conversation with your family members and kind of talk to them about what your wishes are so that they know. But the nice thing is that if something were to happen to you, there's a document that the hospital and the doctors and all your relatives are going to follow.
And how do they find this document?
Well, I tell people all the time, give a copy to whomever it is that, you know, if I decided that, Lou, you were going to make my decisions, make sure I give you a copy, make sure I put a copy with my will, and then I tell people, put a copy in your glove box, because typically if somebody's rushing to the hospital, they're usually driving a car. And if everybody knows maybe they can't find your secret hiding place, or they can't get into your safe to get it because it's with your will, they always should know that they can go to your glove box and they'll find it there.
That's a very good point. I'd never even thought about that.
And then we also keep a copy as well. So if you know that it was prepared at the Baer Law Office, we've already scanned it in, we've got it. I mean, I've had times where I've had to run over to the hospital to deliver it, just to say, you know, they've called and said, hey, do you have it? Because we can't find it. And I'll send somebody over. So,
okay, so you can take care of that too.
Yeah, we can take care of that. Then we have what's called, we have power of attorneys. We have a financial power of attorney, and we have a medical power of attorney.
What's the difference here?
Okay, so financial power of attorney is what you would need. What happens if you have a stroke and you're not able to write checks on your account or pay your bills? Now, if your wife's not on your account, that's going to be difficult for her to get access to your money.
Right.
Or if you're single, it's going to be hard for your relatives to access your money. So the financial power of attorney basically says, if something happens to me, and what our financial power of attorney say is, it only comes into play if a judge has said that you're incompetent or a doctor has said that you're incompetent, whether it's for a short amount of time or it's permanent. And so then what happens is the power of attorney kicks in, and whomever you've nominated to be your power of attorney can take it to the bank and say, here's the power of attorney, you know, I'm now going to be writing checks, and they can make sure your bills are paid.
So they can make the adjustments adjustments to that, and this is for maybe you just don't have the wherewithal to make the right decisions.
Correct.
About your finances.
Yeah, I mean, we have cases all the time where somebody starts showing signs of dementia,
right?
And then if the doctor says, you really should not be making financial decisions anymore, then the power of attorney would kick in.
Got it.
But I always want to make sure people understand it doesn't kick in until then. So if I were to fill one out and give you my power of attorney, it doesn't mean that tomorrow you can go raid my bank account.
Okay, you can take it to the bank and say, hey, she said I can do this.
Right.
Do it like thinking ahead.
Exactly.
Have that already done, because a lot of times you kind of are in a situation where we may need to get this done.
Yeah.
But
and the same thing with regard to medical power of attorney. It basically says this is who I want making my decisions, and they can have. And with our HIPAA laws now, it's just so much more helpful if Lou's my person, for financial and medical, and I say, okay, Lou can have access to all my medical records. Lou's going to make my decisions for me, and maybe I want Lou instead of my sister or my mom or somebody like that, because Lou's been my best friend.
It doesn't need to be a relative.
It doesn't have to be a relative.
Okay.
I mean, it really doesn't. And so again, the financial power of attorney and the medical power of attorney only kick in once either a judge has said that you're incompetent and can't be making these decisions, or a doctor, says those things.
And how long of a task is it to put these together, and how expensive is it?
They're super easy. I think we charge $100 for each power of attorney. If you're getting two powers of attorney and a living will, I think there's a discount. I mean, you can always call your lawyer and ask them what they're charging, but most law firms don't charge a lot of money for the power of attorneys.
Do they expire after a certain amount of time?
They do not. Okay. They do not until you revoke them. I mean, you can always do a new one and revoke prior one. So let's say that down the road, Lou and I have a falling out, or Lou moves to North Dakota or something, and so he's not around, then I want to do another one.
Okay.
Or a lot of times we draft them, and you might be my first choice, and maybe my sister's my second choice. So even though you've moved away and you're not around, now my sister will step in, so we don't have to redo it.
Okay, so would you suggest having a backup?
Yes, I absolutely do. In fact, our form has a spot for a backup, and a lot of times, we tell people, and you don't have to have the same person for medical and financial. I mean, it might be, we all have people in our family that we say, okay, this person is very emotional, and so I don't know is that I want them making these kind of decisions, but guess what? They're really good with money because they're an accountant or they're a CPA, or I know they've done really good investing, so I know they'd be good with financial, but maybe not the medical.
Okay, so how is a living will and these power of attorneys different from just a will?
Yeah. So then a will says, here's where all my stuff is going to go. So a will is just completely separate on its own. So one of the questions when we have people call about a will, we kind of walk them through a few steps, because we're of the opinion that you don't always necessarily need a will, and that's the reason why we were going to ask you lots of questions. All right, if you're married and something happened to you, do you want everything to go to your spouse? Yes, I do. All right, and then do you have children? If something happens to your spouse, then where's everything going to go? Because what we can do is we'll walk you through what the law says, because if you don't have a will, then you're just governed by Iowa law. And so first it goes to your spouse, then it goes to your children, and if you don't have any children, then it goes up to your parents before it goes to your siblings. Okay. So we just kind of walk people through that. But usually when people really need a will is if they've just recently gotten divorced, or they're concerned about minor children, or they've gotten divorced and now they're getting remarried. Because if you don't have a will and you've remarried and you have children, the law steps in and the law puts a limit on how much your new spouse will receive. And we just don't, you see lots of fights that occur afterwards because nothing was set out.
Okay.
So, and again, the wills start at, I think, $400 for a basic will. So, if you already have an attorney, give them a call, but a basic will just really shouldn't cost that much. If you need a trust because you have minor children, or maybe you're going to leave some money to or something to nieces and nephews, and so you want to add a trust into the will, then it starts getting a little bit more expensive.
Okay.
So just all things that you need to be thinking about. And again, most law firms offer a package discount if you have everything.
All right.
So.
Very good.
Yeah.
And it sounds like planning and just having things in place is always a good idea.
And it's an easy process. It really is. I mean, we
use down the road, or
it does.
hardships on your family.
Yeah. I mean, because the other thing is we also have gotten calls to come over to the hospital to have somebody do a power of attorney, and then for us, we always have to take a witness and ask all sorts of questions, to make sure that they're competent to sign it.
Right.
So
all these things taken care of ahead of time.
Ahead of time.
That's the key here.
Yes. Just do it and throw throw it in your glove box and forget about it.
Forget about it. That's
Yes.
a great idea. And if
Yes.
people want to get a hold of you, Kim, and get
Yeah.
information about how to do everything we just talked about,
Sure.
easiest
sure.
way is?
Yeah, just give us a call at 279-2000. We offer a free consultation, so come in and have a cup of coffee.
All right.
So,
Very good. Thank you. Great information as always.
yeah.
Thank you,
Good to
Kim
see you
Baer.
guys.
It is